Be ready. Start. Professional ethics require that a lawyer cannot refuse a brief provided a client is willing to pay his fee and the lawyer is not otherwise engaged. Hence, the action of any bar association in passing such a resolution that none of its members will appear for a particular accused, whether on the ground that he is a policeman or on the ground that he is a suspected terrorist, rapist, mass murderer, etc., is against all norms of the Constitution, the statute, and professional ethics. It is against the great traditions of the bar, which has always stood up for defending persons accused for a crime. Such a resolution is, in fact, a disgrace to the legal community. We declare that all such resolutions of bar associations in India are null and void, and the right minded lawyers should ignore and defy such resolutions if they want democracy and rule of law to be upheld in this country. It is the duty of a lawyer to defend no matter what the consequences, and always who refuse to do so is not following the message of the Gita. Be it noted, in the said case, the Bar Association of Coimbatore had passed a resolution that no member of the Coimbatore Bar Association would defend the accused policemen in criminal case against them in the said case. The right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. On a studied perusal of the said decision, it is noticeable that the court has stated about the role of the lawyer and the role of the bar association in the backdrop of professional ethics and norms of the Constitution. It has been categorically held therein that the professional ethics require that a lawyer cannot refuse a brief provided a client is willing to pay his fee and the lawyer is not otherwise engaged, and therefore no bar association can pass a resolution to the effect that none of its members will appear for a particular accused, whether on the ground that he is a policeman or on the ground that he is a suspected terrorist. We are disposed to think that in Muhammad Sukur Ali Sopra, the aforesaid case was cited only to highlight the role of the bar and the ethicality of the lawyers. It does not flow from the said pronouncement that it is obligatory on the part of the appellate court in all circumstances to engage amicus curiae in a criminal appeal to argue on behalf of the accused, failing which the judgment rendered by the High Court would be absolutely unsustainable. A two-judge bench of this court was dealing with a criminal appeal which had arisen from the order of the High Court, whereby the High Court, on perusal of the judgment under appeal, had dismissed the criminal appeal challenging the conviction. The court referred to section 423 of the old code and came to hold that the criminal appeal could not be dismissed for default of appearance of the appellants or their counsel. The court has either to adjourn the hearing of the appeal or it should consider the appeal on merits and pass final orders. It is further observed that the consideration of the appeal on merits at the stage of final hearing and to arrive at a decision on merits and pass final orders will not be possible unless the reasoning and findings recorded in the judgment under appeal is tested in the light of the record of the case. The court referred to the earlier section 421 of the code which dealt with dismissal of an appeal summarily and was different from an appeal that had been admitted and required to be dealt with under section 423 of the code. It is no doubt true that if counsel do not appear when criminal appeals are called out, it would hamper the working of the court and create a serious problem for the court. And if this happens often, the working of the court would become well nigh impossible. We are fully conscious of this dimension of the matter, but in criminal matters, the convicts must be heard before their matters are decided on merits. Thank you.